In the last week and a half, the Supreme Court has ruled on key decisions in American life, like the right to a concealed weapon, religious rights, and the rights of the unborn.
It has been quite a week. So where could the court go next? We bring in an expert, Howard Schweber, professor at UW-Madison, an expert in constitutional law. I'm telling you, folks, this is the guy to turn to, and he's joining us on the couch here to talk about it. Professor Schweber, great as always to see you. Thanks for being with us.
Thanks for having me.
What a week, huh? Pretty wild.
Truly remarkable. In the space of 4 days, 4 business days anyway, this court has announced dramatic and major new changes in long-standing doctrine. This is changing principles that have been in place for 60 or 70 years in 3 of the most hotly contested, most central areas of constitutional law. As you mentioned, abortion, guns, and religion. It's really hard not to see this as a deliberate kind of declaring this is a new era is dawning. I mean, to issue dramatic decisions on such major areas in such short order really feels like the court staking out a position that going forward we're going to be a new and different kind of court.
And Justice Clarence Thomas signaled that he'd like to take another look at some of these cases that have to do with personal rights. Do you think that that could be happening?
I think it absolutely could. So Thomas takes the most radical position. It is a position he's taken for years. I don't want this to be misunderstood. He wants to go back to the 1870s, not in the sense of saying we should only have the rights we had then, but in the sense that he thinks something went fundamentally wrong in the way we do constitutional rights, so we should go back to that and start over. The problem, of course, is that's throwing away everything that's been done in the intervening 150 years, and I don't think anybody else is at all eager to do that. But several of the justices have given signals that they might be interested going forward in looking at cases like Lawrence and Obergefell in particular. Those are the cases about same-sex intimacy and same-sex marriage. And the logic that the court used to strike down abortion in Dobbs applies really pretty on the spot to those cases as well. So there's a very serious concern that those cases in particular might be targets going forward.
And we talk about rights and some, but you say there's another thing to look at in terms of powers of agencies, and that's another thing that could be a discussion in the court.
Absolutely. So the background here is that this court is trying to establish a new, judicially conservative set of principles about how it interprets the Constitution. And those principles don't only apply to things like rights, they apply almost more importantly to things like the relationships between the states and the federal government, the powers of Congress, the powers of executive agency. There's only one major case left in the docket right now, West Virginia versus EPA, and it will give this court an opportunity, if it wants to make as radical a change in the relationship between Congress and federal agencies as they've already struck on the question of rights. And frankly, I expect them to do so.
A lot of people seem concerned that in doing some of these things, we are now shifting more toward an activist court rather than a non-partisan court. Is that a concern at all?
Well, I mean, there's no question this is a wildly activist court. Depending on how you measure activism, which is always an interesting question, it's arguably the most activist court we've ever had, or the most activist in X number of years, and so on. By activists, I usually mean eager and willing to second-guess the other branches of government and eager and willing to overturn long-standing precedents and principles. And certainly this past week has made it very clear that on the latter point, the Roberts Court is eager to be active and to reshape not only the rights, but how we think about, how we argue about questions of constitutional rights, and that will be influential in judges and lawyers for years to come.
And we hear about the politician Tom Nelson earlier talking about court expansion that he's pushing. Mark Pocan tweeted about it the other day. What is next for the court in your view?
Very little institutionally. I don't think there's the slightest possibility that the court will be expanded. It's worth noting that historically the number of justices on the court has fluctuated. 6, 7, it's been 9 for a while. But there's never been a successful attempt to change the number for political reasons in order to get a different outcome. The guy who came closest was FDR, and if he couldn't do it, I certainly don't think that President Biden can pull it off, nor does he want to. I think the court will continue to go on in this way. These justices will be in place for a long time. I think this week is the beginning of a new constitutional model, a new era. And I think it will be years before we figure out all the details and the limiting principles and how it applies in different situations. I really think this week was the beginning of a very, very major change in the way our Constitution is interpreted by our federal courts.
It's absolutely fascinating. It's always great to have you as a resource here
to
walk us through these things. So thanks for being with us.
Thank you.
Appreciate it. Howard Schweber from UW.